is the Investor Connect podcast program. This is Hall T. Martin. I'm the host of the show, in which we interview angel investors, venture capital, private equity, family offices, and many other investor groups for startups and growth companies. I hope you enjoyed this episode. Thank you for joining us. Well, hello, this is Hall Martin with Investor Connect. Today we're here with Chris Ezold, partner at Wister Pearlstine. Wister Pearlstine is a Pennsylvania-based law firm specializing in business, employment, and corporate law. They help startups and investors navigate legal challenges. Christopher, thank you for joining us.
Thank you very much, Hall. It's a pleasure to be here.
Great. And where are you calling from today?
I am calling from my office at home, but my primary office is right outside of Philadelphia.
Well, today we'll be talking about lawsuits and fraud. Are there any emerging legal risks or trends in lawsuits that businesses should be preparing for here in 2025?
There are quite a number, and it ebbs and flows, and this year, next year is going to be significant. If we see a disrupted economy or a recession, failure to pay, bankruptcy issues are going to be a big deal. So if you have debts, if you have obligations from others, you want to make sure you get a secured debt if possible. Cybersecurity and privacy is absolutely an emerging area. There are going to be a lot of conflicts because every state has its own rules or no rules. And since companies, especially emerging growth companies, are far flung, they have employees all over the place. The different states have different laws and which one applies, et cetera. And since everyone's got IP, that's going to have some impact. Supplier contracts and logistics are going to have stress. So that is an area where we're going to be seeing, I think, a number of disputes. Cryptocurrency, of course, which has been that way for a while. We're seeing a rise in the power of employees. So labor and employment issues are definitely on the rise in litigation. There's a lot of M&A right now, which for emerging growth companies is great because you hit a liquidity event. But many of those liquidity events have earnouts, payments over time, et cetera. And that's going to lead to an increasing number of disputes post-closing.
So what are the most common legal missteps that lead businesses into lawsuits? Where are they making these mistakes?
Every business ignores problems on occasion, and emerging growth companies are more guilty of that on average because they've got so many things to do and not enough people. And so some things are just left to fester. Employment issues, especially if left to fester, will turn into serious potential risk and litigation. Same thing with vendors, non-performing vendors, organizations that owe you money, and all of a sudden you're 120 days out and you just kind of ignore it. That's going to create a problem and litigation instead of having cut it off earlier. Failing to document issues. You have an agreement with somebody, it's a verbal handshake, and they don't abide by it, and then they claim you never spoke. So documentation is always key. Not getting your attorney involved in time. You can show up with a deal that you think is great. You talk to your attorney, you've already done all the work on it, and your attorney tells you, no, you can't do this. And now you have a problem. And the other side may sue you for doing something or not doing something you said you'd do. And then neglecting your intellectual property, especially if it's a trade secret, can absolutely lead to litigation. So that's something you have to keep an eye on constantly.
Right. Well, in your experience as fraud in business, is it typically intentional deception, or more often is it just a result of poor oversight and not taking care of business?
Fraud, by its definition, is intentional. But most people aren't out there doing business saying to themselves, how can I steal money from somebody else? How can I hoodwink somebody? Instead, what happens is you get the negligence on either side that creates an opportunity that just kind of drops in someone's lap and gives them a chance to grab some money, grab some intellectual property, whatever it is, and think they can get away with it. So the behavior is intentional, but usually it's the negligence, the failure to operate your business well, that will lead to the opportunities for someone to commit fraud.
What's one of the most complex business fraud cases you've encountered? What were the legal lessons you took from that?
The startup emerging growth area, one of the more complex issues was a large private equity fund promising to put money into an existing entity. And there were a number of investors. They were on the board. They were cooperating with everybody. And they pushed the company to take a number of steps, promising the money would be there. And of course, it wasn't. Now, that's something you hear about from time to time, but this appeared intentional to me because the next step was this particular investor then trying to push the company to sell at a fire sale price. So they intentionally caused the company to take steps to put itself in a bad spot so that the company would crumble and then try to buy the company's assets at a fire sale price. It was complex because it's hard to determine exactly who struck John and how things happened because you don't have all the inside documents from the investor, but we were able to put together a fair amount of material that made it clear to us what we felt was going on. The lessons from that are don't put yourself in a bad spot unless you've got a contract. The problem was this was a board member and an organization that my client trusted implicitly, and they shouldn't have. They should not have taken the steps to put themselves into potential debt without the money in hand from the investor, without the promise.
I've heard of a case where the founder actually put the company into debt and then, forced it somewhat into involuntary bankruptcy. The vendors just, got tired of waiting for it, so they pushed it into a bankruptcy. And that was their whole plan all along, was to go into bankruptcy so they could then buy out the assets from bankruptcy and wipe out the investors along
Right.
the way. Is that a common technique, or is that just something pretty rare?
I think it's rare, but it does happen, and it happens more often with intellectual property than other assets. Because if you get pushed into a bankruptcy and you have to liquidate, and you have assets that are real estate, inventory, something hard that's tangible and has value, people are going to buy it and maybe they'll outbid you. But if you're, one of the people pulling this scam and it's intellectual property that's really useless to anybody but you as the founder, then it's a much more likely that you're going to want to try this rather than if, you want to try to get your inventory for a song. And it lets you start the company all over again, having developed that IP with somebody else's money who no longer has any equity in the game.
Well, what about non-compete and non-disclosure agreements? Are they enforceable? Do they end up in lawsuits as well? And what do you see in today's legal landscape there?
They're increasingly unstable from a legal point of view. There have been a lot of attempts at the national and state level to restrict or eliminate non-competes, and judges historically have not liked them. Now, there's some developments where even though the FTC wasn't able to get rid of them entirely, lots of states have started passing laws that restrict the amount of time or the type of entity or the type of person or worker that can be bound. While at the same time, there are some judges who are beginning to become more friendly to them. So it's a very fluid legal landscape. But what that really means is you have to have a really well-drawn non-compete, and you need your attorney to know what you need. Many of my clients really don't need a non-compete. They need a confidentiality agreement, and they need a non-solicit so that the employee won't take clients, won't take investors, won't take employees and contractors and vendors, won't interfere with their business. But go work somewhere else, that's fine. Just don't take my stuff. And mostly that works for clients. Not all the time. Sometimes you really do need a non-compete. But knowing what you need and getting it right and getting it narrow will help ensure that it's enforceable for you.
What are some lesser known ways that fraud can occur within a company? What should a CEO be looking out for?
There are as many ways to commit fraud hidden in a company as you have line items in a financial statement. Overvaluing assets so that investors will put more money in than they should or at a higher valuation than they should, reducing expenses, same thing. Moving your income or expenses into a different year so that it appears that you're doing better or worse than you really are. Manipulating earnings, same thing. There are employees who create fictitious vendors and then pay out this vendor for things that you don't get or massively overpay. expense report fraud, inventory fraud, telling you don't have things you actually have, and then someone takes them and sells them, or vice versa. Tells them you have all the things you think you have, but you don't, and they've been stolen out from under you. Collusion with competitors. You have some people that, when they're working for a company, are willing to collude with a competitor for a paycheck or a better job in a year, things like that. IT sabotage is beginning to become a larger issue, especially with departing employees or people with whom the company has a dispute. It's easy to go in and start deleting things or taking things or changing things, and that can create very serious issues. Data theft, very much the same thing, and very much an emerging problem.
Well, if a company discovers potential fraud or legal violations internally, what steps should they take?
So don't ignore it is absolutely step one, because you could lose your rights simply by failing to pursue them quickly. Get your attorney involved ASAP. Sequester everything. All your data, all your records related to the issue, have your IT people ghost them onto another drive somewhere that you have, so that you have a snapshot of what your data, what your financials, et cetera, look like at the time. You start an immediate investigation with somebody who knows what they're doing. If you don't do investigations, don't do it yourself, because you're not going to do it right. And then look ahead to the impact. What's the worst case scenario? What's the best case scenario? Prepare a plan so you can be flexible in dealing with the fallout. Frequently, you can catch the person doing fraud dead to rights, but they've got no money. And so you're hurt, they can't repay it, and you're still unable to get a remedy. So make sure that you're flexible enough to have the plan to give you some space, do what you need to do to get back on your feet.
Have you worked with a client facing legal troubles? And if so, what strategies did you use to help navigate the situation?
I've worked with a lot of clients facing legal troubles, either troubles that are trailing and they're coming to them, or we can see coming down the line. If you know litigation is a likelihood, make sure that you preserve what you need for the potential lawsuit. Preserve the emails, preserve the text messages, preserve the data, the information. Make sure you know who the witnesses are and you can maintain a relationship with them and have the information to contact them. Make sure you quantify the issues, impact and longevity. How much is it going to hurt? How long is it going to last? So you can prepare a plan to deal with it. Check your insurance. This is absolutely critical. It's critical, frankly, to have insurance upfront and have the right insurance. And so a good broker and talking with your attorney will help you find what you need, because frequently the insurance will pay for your defense. And they either pay your attorney or they give you an attorney. Usually these attorneys are very competent because it's all they do is this work for the insurer. So that's pretty critical, because that's where most of the cost can be, is the expense in having the attorney involved. And then ensure you have the relationships with the necessary people. You can have a great case, but if it depends on witnesses who you've angered, you may not be able to get your case to trial. So make sure you maintain the necessary relationships so that you've got the ammunition you need, because allegations are one thing, but you have to prove them, and you prove them with documents and you prove them with witnesses. And those are the things you're going to need. And if you don't have them, then you're going to lose.
Mhm.
Make sure you have good relationships with those people.
Right. Well, what's one critical piece of legal advice every business owner should know to protect their company?
I'm an attorney. So the first thing I'm going to say is make sure you have a good attorney, not just a good attorney, but have an attorney who knows you, knows your business, knows your people, knows your vertical, knows your plans, and advises you early on. You want a team member. That's an absolute must to help avoid litigation, because as a business owner, as an entrepreneur, as a founder, et cetera, you wear a lot of hats, but you should only wear the hats that you're competent in. If you're not a bookkeeper, don't do your books. If you're not a scientist, don't run your clinical trials. If you're not a lawyer, don't draft your contracts, et cetera. So you want a good team member to start. You want to be honest with that person. Your lawyer's not out to get you. If you feel that they are not the right lawyer for you. You need to be very honest and transparent with them so they can actually help you. I've had a lot of clients who didn't want to tell me what was going on, or didn't want to admit they screwed up somewhere or made a mistake, or did something wrong, and I wasn't able to protect him because of it. It happens. And I've seen plenty of times when it's on the other side and my opponent gets caught because their client wasn't transparent with them. I'm not going to sit down and say, no big deal, take your time, get it figured. I'm here for my client and I'm going to go do what I need to do. So make sure you're transparent with your lawyer, otherwise you're going to have a real problem. Skating on the edge of legality invites disaster. Don't do it. If you think you're going to need to do that, then you've got to have your attorney on board from day one and get a legal opinion saying you can do this. It's really close, but you can do it. And one of the reasons you get a legal opinion is if they're wrong, well, their malpractice insurance may have to pay. But you also want to be able to say to the government, to other parties, I thought what I was doing was legal. My attorney said so. I have an opinion. And that way it removes willfulness from the equation. That's important. A lot of laws will punish you so much for violating them. But if you did so willfully, those punishments, those civil money penalties, et cetera, mount and can turn into felonies, which means jail time. So that's one of the most serious things you can do is make sure if you're not clear if what you're doing is legal, that you have an opinion that you can rely on.
Well, so it seems in a fraud case you have two choices, either civil or criminal. How do you know which way to go? Should you contact the civil authorities and do a lawsuit, or should you go after the criminal authorities, the FBI, the state attorney general's office, and try to go that direction?
That's a case-by-case analysis
Hmm.
because you can do both. You don't have to pick one or the other.
Oh,
The criminal claims are merely that. Someone violated the law, they need to go to jail, they need to pay restitution, et cetera. Civil claims are different. Hey, you wronged me, you owe me money, you owe me X, Y, Z. You can do both of these at the same time. Sometimes they're not worth it. Sometimes you want to do the criminal first. Let the U.S. attorney, let the prosecutor, whoever it is, work the case up, start getting information you otherwise wouldn't be able to get. And then you can use that to put your civil case together. You have to be careful because the civil case has a statute of limitations, frequently 2 years, but it depends on the matter in the state. And if you wait too long, you could have all the evidence in the world, but it's too late. You're not allowed to bring the suit. So it's something you work out with your attorney. What's the best thing to do? Sometimes you don't want the U.S. attorney involved or the state attorney general, because if they get involved, they may get the money before you do. And if all of the money goes to a civil money penalty to the government, well, you're never going to be first in line. So you may want to do things on your end first to make sure that you can get paid, get your money back in your company, and get back on your feet.
so if you go the criminal route, which authorities do you go to for, typical business fraud?
Again, it depends. Most of the time, it's going to be the state attorney general.
Okay.
And sometimes you're going to want to go to the local counties and go to the prosecutors there. Different counties will have different programs in the prosecutor's office relating to kinds of fraud that they're going to be prosecuting. Depending on the state attorney general's office may have certain programs, certain areas where they're really focusing, and you want to know what those are and which of those two is going to be most effective for you. Sometimes you go federal, but most issues are not federal. They have to cross state lines, violate federal laws in a particular way, et cetera.
Mhm.
And there aren't enough U.S. attorneys to prosecute every piece of fraud. Frequently, they'll say, well, it looks like they did something wrong, but take it to the state, take it to the county. So again, it'll depend. You need someone who knows what they're doing to tell you which of the three is the best to pursue.
And what does it take to get the authorities to move on it? How big of a case, or how much money has to be at stake, or how many people need to be defrauded before that ranks on their list of things to do?
Well, it depends on if it's an election year, and I'm somewhat facetious there. But the reality is there aren't enough prosecutors and there aren't enough U.S. attorneys.
Right.
And if you go to them and say, well, I think someone did something amorphously wrong, go figure it out. They're going to say, I got stuff to do. I can't help you. But if you're able to get some of the legwork done yourself and you build a case and you get the documents and you get the evidence together and you talk to witnesses and you put it together and you can hand it to them and say, look, I've done a lot of the work. Here's the evidence showing, or the beginning of the evidence showing a violation. And oh, by the way, Here's the harm. It's not just they stole some money from me. They're doing these things. It's having this impact. For instance, if you're a medical practice, you can say, look, now because they've done something that's going to shut my practice down, there aren't enough whatever kind of doctor in this area to serve your citizens. If you're developing a drug, this would help kids in need, but now it's going to be years down the road before it gets anywhere because this person stole from me. That's going to hurt people. Showing how it hurts the constituents of the particular law enforcement agency you're talking to will also make a difference.
Well, it seems like there's a fine line between fraud and failure. Sometimes, the entrepreneur just tried their best and it was failure, but sometimes they were doing things intentionally to fail and calling it, which is actually fraud. And how do you determine the two, or how can you draw the line between the two and show, well, this was really fraud. They knew that what they were doing was that way.
It's very difficult sometimes. The whole nature of being an entrepreneur, being a founder of a business, having an emerging growth business means taking risks. So you're taking a lot of risks here. And frequently you don't know until you're done whether that was a ridiculously optimistic thing to do that no person in their right mind now would do, or if it was a great idea. And that's why it's a risk. So you can have different levels of behavior. You can have sort of what's called garden variety negligence, basic negligence. You can have recklessness, where anybody would recognize what you're doing is almost certainly going to end in disaster or has a very high risk of that. And then you have intentional behavior, where you know that what you're doing is going to hurt someone. But very rarely does anyone say, I know I'm going to hurt someone, and write it down and put it somewhere for you to find. So that's the hurdle you have to reach, where you have to show that they knew what they were doing was A, fraudulent, they were lying, they were misrepresenting something, et cetera, and B, that it was going to hurt people and not result in what they were doing. And that can be difficult. Sometimes you just have to convince people by the circumstances as opposed to having a smoking gun. There very rarely is a smoking gun. And if there is, you never get to trial. Because if you got a smoking gun, you're going to get that case settled in almost all circumstances.
I heard of a case once where they came from New Zealand to the US to start a company. They started it, ran it, and then suddenly the money disappeared after a few years and they all went back to New Zealand. What do you do when they go international on you like that?
I'm actually doing a few deals right now down under, and it's very difficult. You have to determine where the contracts are, because if they come here and invest and we make these Delaware contracts, I can sue them in Delaware and get a judgment in Delaware, but what I'm going to do with it, they're back in New Zealand or Australia or wherever they happen to be. So you may want to get those contracts to be Australian contracts,
Hmm.
much easier to enforce in Australia. You don't have to go and domesticate your judgment overseas, which is sometimes extremely difficult or impossible to do. Having a plan for the what if and knowing which of your legal documents you need, and maybe you have documents in both the United States and Australia, to make sure that you can enforce your rights in either location is important. And of course, you got to do your due diligence. So they have money, they have assets, because they can come here and run my business into the ground. But if they've got no money, then I'll never have a recourse. Maybe I don't want to do business with them if I know I'm never going to be able to catch them. And if I do, they've got nothing to give me.
Hmm. I see. Well, great. Well, in the last minutes that we have here today, what else should we cover that we haven't?
So I really do want to circle back to the concept of using your attorney as a team member and being transparent with them. Just like any one of your team members, your team members are tools. You use them for various things. You use your CFO to handle your accounting and your financial statements and make predictions about cash flow that you can rely on. And if you lie to your CFO about money you have coming in, et cetera, then all of the work that that person does is worthless and you cannot rely on them. Not because they're bad, but because you're not trusting them. Same thing with an attorney. If you don't trust the attorney, if you're not transparent with them, that attorney is not going to be able to do their job for you. And I've had plenty of times where a client didn't tell me something they should have, which had they told me in time, I could have avoided the problem, but they didn't. And by the time they fessed up, it was too late. So having that trust, treating your team members as team members is a very big deal. And it is absolutely necessary to make sure that you don't step in one of these potholes. Because if you don't want your attorney to tell you no, that's a bad idea. So you don't tell them what's going on. Well, guess what? You're going to do the thing that's a bad idea. And then you're going to be shocked that it's a bad idea. And it has consequences. Instead, your attorney can recommend a way around it, a different manner of doing what you need to do so that you can get it done. Maybe not as well as you would have liked, maybe not as profitably, et cetera, maybe with more hoops to jump through, but at least it's done and you're not in the middle of a piece of litigation. Litigation is bad. You never want to go there simply because it's expensive and time consuming and it really hangs over your head. It's a shadow, a cloud over your life for quite some time. They're never short. Lawsuits or arbitration matters, they take a lot of time, a lot of effort. They drain you personally and they drain your company. So it's far better to avoid them than to take a risk that you're going to get into one.
Well, this has been an insightful interview. How best should listeners get back in touch with you?
You can go to our website, www.wisperl.com, and reach out to myself or any of my partners. You can always reach me at CEZOLD, that's my first initial last name, Ezold, at Wisperl, WISPERL.com. I work almost every day, and I'm always checking emails, so if there's an emergency, you can absolutely get a hold of me or call through to my number, and usually I'll pick it up on my cell phone and get back to you.
Right. We'll include those contact details in the show notes. I want to thank you for joining us today and hope to have you back for a follow-up soon.
Thank you so much, all. It's been an absolute pleasure.
Investor Connect helps investors interested in startup funding. In this podcast series, experienced investors share their experience and advice. You can learn more at investorconnect.org. Paul T. Martin is the director of Investor Connect, which is a 501c3 nonprofit dedicated to the education of investors for early-stage funding. All opinions expressed by Hall and podcast guests are solely their own opinions and do not reflect the opinion of Investor Connect. This podcast is for informational purposes only and should not be relied upon as a basis for investment decisions.